We're going live on the record on cause number DC 203457, Lionheart Holdings LLC versus Heather Allen. This case was set for 9 o'clock. It is now 9:16. The plaintiff has not appeared, who filed the motion for new trial. Mr. Vassar, I believe, is here for the defendants. Is that correct, Mr. Vassar?
That's correct, Your Honor.
And you are the respondent to this motion, is that correct?
Yes, we filed a response to the motion for new trial last week.
All right, go ahead and begin your argument.
Your Honor, on behalf of defendants Heather Allen and Patrick Giaci, you signed a final summary judgment in favor of my clients on October 9th. That awarded them damages and attorney's fees and dismissed claims that were made against them by plaintiffs Colabotos and Lionheart. Plaintiffs thereafter filed a motion for new trial. We did file that response last week. Your Honor, we also filed a motion to strike to the extent that that was filed on behalf of plaintiff Lionheart, because it was not filed with a licensed attorney representing Lionheart. And of course, Lionheart must be represented by an attorney. I understand Colabotos could still pursue the case. They have not appeared, as I suspected, or as I surmise. I think they've lost interest in this. The property is no longer in their possession. They do have other litigation out there, and they have 4 or 5 different grounds in their motion for new trial. I am happy to discuss why those grounds don't carry any weight here. Newly discovered evidence, and they did not, come up with any, obviously aren't here with any. They claim improper conduct in the court proceeding. That final judgment was rendered after a summary judgment motion in which there was no response filed by the plaintiffs. You still let them be heard at the hearing and let them talk. Then you granted our motion. The third ground is improper damages. I'm just putting that in quotes. The damages awarded to my client were supported by a summary judgment affidavit, which again was unchallenged. Then they state that they were not afforded legal representation. That simply wasn't the case. I know Your Honor's had several cases since then, but as Your Honor might recall, they filed this lawsuit themselves. They are plaintiffs with Jason Ciarocci as counsel. A ton of fighting and attorney's fees later, he filed a motion to withdraw in July, was granted the opportunity to do so in August. At that time, you told plaintiffs they needed to obtain counsel. We didn't file our motion for summary judgment until about 3 weeks later, and you didn't hear it until October 5th. So there was plenty of time, which Your Honor did note at that summary judgment hearing. Finally, there's kind of a generic statement that the motion for new trial, that they have a meritorious defense, and granting a new trial would not injure our side. Again, there's no substantiation for that. The merits of the case have been determined on that motion for summary judgment, and the prejudice is apparent because of the skirmishing that happened early. Attorney's fees were almost $24,000. So clearly, if we rip this up and start it again, there would be prejudice to my client. So we're asking that the motion for new trial be denied. I have not submitted an order yet, but I do have one. I can either email it and or e-file it.
Can you go ahead? Yeah, the court is going to deny the motion for new trial. Can you go ahead and email that to my court coordinator as well as e-filing it, and we'll try to get that signed hopefully today.
Certainly will, Your Honor.
All right, Mr. Vassar, you be safe out there, and that will conclude the hearing. Thank you so much.